Johan, I'm moving into my new complex, my unit, and it's moving day, and I'm bringing in my pets, and we're excited, and they say, you're not allowed to bring your pets. Please move them out or move out. What do I do?
Amoré, we had numerous problems with pets, and obviously the interpretation of the rules of the relevant sectional title scheme. Just a bit of a technical jargon is that when a sectional title scheme is opened, there has to be rules. Now, whether the specific developer decides to create his own rules, in other words, niche rules that he physically writes for custom-made purposes, there are rules that are prescribed as standard rules in the Sectional Title Schemes Management Act. And these specific rules are contained in Annexure 1 and 2. Now, they consist of management rules, which normally regulate the trustees and how they got to function and the like. But the conduct rules in Annexure 2 is very important, because in the absence of any other rules, those are the rules that basically apply. Now, I can quote out of those specific rules, and the conduct rules start with owners having pets. It basically says that owners or the occupier of a section must not, without the trustees' written consent, which would not unreasonably be withheld, keep any animals, reptile or bird in the section or on the common property. So as a standing rule, and if they adopt and the standard rules as prescribed by the Sectional Title Schemes Management Act, it normally does not permit animals of any nature. So, you know, it might be that they've deviated from these specific rules by amending the standard rules, but for any prospective purchaser and estate agent for that matter as well, working in that complex, it's of the utmost importance that you have to study the applicable rules that actually applies on a body corporate or the members of the body corporate, because those rules should and would basically regulate the keeping of animals and the conduct of animals and their owners and the like. So that is of the utmost importance, and there's very little you can do. The contract will not overrule those specific rules that apply. So even if your contract says you can bring your two big Dobermans onto the sectional title scheme, if the rules do not permit it, or you've omitted a specific consent or written consent from the body corporate, that would be devastating. So it is a responsibility which I think both the purchaser and the relevant estate agent has to acquaint himself with those specific rules.
Yes, I always advise people that if this is something that is a deciding factor in you buying this property, and that is your dog or your cat, then you need to make sure before you even sign a contract that you don't take anyone's word for it, but you ask for the house rules, because the house rules will be the determining factor. I've seen this over and over where people mid a transaction stop the transaction because of that fact. So you need to make sure, like we always say, do your due diligence as a buyer before you go through this whole process and start attaching yourself to the property if this is important. And the adoption of normal rules are in fact true. They can be registered in the deeds office in the beginning. But as time goes by and AGMs are done, people feel different about the rules that was there in the beginning. They change. And with that, it needs to go through all the customs and processes. So when it says no pets allowed, and you say, well, I apply for my pet, it will still be no. It won't overrule, you won't be treated in a special way. The one question that I'm thinking of now is, well, Johan, I've got an emotional support animal, or I cannot see, I need my guide dog. Will this override the rules that there's no dogs or cats allowed in that complex?
No, it won't. The concept is that, you know, irrespective of the circumstances, the only guideline we have in that regard is that they say it will not unreasonably be withheld. I believe that if there is a person without sight and he's got a guide dog, I think that would be probably unreasonable to withhold that consent and make an exception to the rule. So there can be exceptions to the rule, and it has been done in numerous instances, you know, where they created a pet problem during the years, like you said. You get a lot of body corporates that say, all right, we're going to phase out the pet. So you are allowed the existing pet that you have, but you're not allowed to replace it. So what's important as well is that the purchasers should not only acquaint themselves with the generality of the rules, but they should basically approach the body corporate and say, guys, have you had any changes to these rules? Have you, by means of a special meeting or special general meeting, have you changed the rules and adopted different approaches with regards to pets? And can I please have privy to those, because it's important when I make the decision. And then lastly, if you are not 100% sure, or even if the rule is not very clear about this specific situation, you can always bring it in as a suspensive condition in your contract. So you can make your contract subject to it and say, all right, I love the place, I'm going to buy the place, but it's going to be subject to my own short due diligence of a day or two, that I can ascertain whether I can bring my dog in or not, and it would be subject to the written consent of the body corporate that I need to obtain. So you can basically stall the contract and the effectiveness until you've been able to comply with that necessary requirement.
So what you say is you can't, like you said in the beginning with the Dobermans, you can't have a suspensive condition in your contract that says, I can bring my dogs. It won't overrule the current rules of the complex. But what you can do is you can say, if I can bring my dogs, then I will buy this property. So that's the different kind of clause that you can put in the contract, because it's very important. Only, like you said, if a complex has that rule stating with permission, not unfairly withheld permission, you can keep your dogs or your cats, but that is only if it states there. Some complexes clearly state no pets allowed.
Correct. And that I think primarily is the purchaser, it's his responsibility to do that. I mean, if I have omitted or neglected to peruse the rules, we got to remember there are clauses in terms of the OTP that says the purchaser has done his inspection with regards to the property. He purchases the property subject to the existing rules, title deed conditions, and the like, which is a serious in nature. So you can't come back later and say, but I was falsely brought under the impression that I could bring my dogs on the premises. You have to make sure that you acquaint yourself with those specific absence or presence of guidelines or permissions before you do that. Because ultimately, if you neglect to acquaint yourself with it, you will be bound by the contract. You will be forced to proceed with the transaction, irrespective of bringing your dogs along or not.
So what you're saying is you can't midway say, I wasn't aware of this, I'm now going to withdraw my offer and look for another property. It's not as easy as that, because you did not state that this was as important to me that I would bring it in as a special condition. There's always a space at the bottom of a contract that's a special condition. If this is important, write it in there. But if it's not, then everyone assumed, and not even assumed, but noted, because it was in the contract, that you made sure you did your due diligence and you are happy with the contract condition of the property, the location of it, and all the rules of it. You cannot then withdraw your offer without being liable for all the costs.
I think to summarize it, Amoré, it's very important that ignorance is not a defense in law. So that is unfortunately it. A lot of people, plead ignorance, whether it be seller or buyer, but at the end of the day, you will be in a very difficult position to sell something to a judge or a magistrate to say that I didn't know. Then they would probably have a specific counter argument to say that you should have. It's your responsibility to investigate, to make sure what you're buying is what you intend to do, and that it complies with your requirements at the end of it.
And especially if you are outside the complex, be vigilant, because boards are up that says no pets allowed, or special conditions of the complex are there. So even later on, if you say, but I wasn't aware, and someone would show the judge a photo of the outside of the complex where it clearly said no pets allowed, your case will not have any validity in it.
Correct, 100%.
Thank you, Johan. I appreciate your time.
My pleasure.